So there are two major Second Amendment cases that are sitting in front of the Supreme Court, and by July, they could help reshape the entire Second Amendment and the litigation going on right now in multiple cases. So let's talk about what is happening. Now, before we jump into this video, I want to thank one of the new sponsors of the channel, which is Patriot Mobile. For 10 years, Patriot Mobile has been the only company in America, the only wireless provider that has Christian conservative values. Patriot Mobile offers dependable nationwide coverage, giving you the ability to access all three major networks. That means that the same coverage you would get from those companies is the exact same that you would get from Patriot Mobile. And you can also then support a company that has the same values as you, which is pro freedom of speech, pro 2A, and pro freedom. I first met Patriot Mobile over at SHOT Show. I met their whole marketing team. I got to have conversations with them, and they seemed like a really cool company. And they were actually sponsoring, SHOT Show, which is a big deal. And also, they are 100% based in the US, which means that if you need to call customer service, they're all here in the US, and I believe most of their team is actually in Texas. So I recommend that you guys check out Patriot Mobile if you're interested. You can go to patriotmobile.com/scholar, or you can call 972-PATRIOT. And if you use the code SCHOLAR, you can get a free activation fee. So again, really excited about this sponsor, a really cool company. They have the same values as us. And if you guys are interested, again, check out those links. As I mentioned in the intro, in this video, we need to discuss some huge Second Amendment cases that the Supreme Court will rule on in just a month. One of the cases is currently sitting in the shadows, but will be very important going forward for the Second Amendment cause. In this video, we're going to be discussing a case called Range versus Garland, and it involves a challenge to the federal laws which prohibit someone with a nonviolent felony or a misdemeanor equivalent from being able to own, possess, or acquire firearms. This case is critical to outline how the Supreme Court's Bruen analysis should be applied going forward in these type of cases and then other 2A cases as well. This case has become even more important in light of the recent oral arguments that the Supreme Court held in a different case called U.S. versus Rahimi. The Supreme Court is set to decide the Rahimi case, and that decision will be coming before the end of this term, which is going to be in late June, early July. So the Rahimi decision will happen in just a month, and the Range case was recently put on hold because of that pending Rahimi decision, which means that these two cases are now intertwined, and the outcome of the Rahimi case and the outcome of the Range case will likely very soon reshape future 2A litigation and impact a lot of 2A cases that are currently developing. Now, the Range case originally found its way in front of the Third Circuit en banc panel because 26 years ago, an individual, Brian Range, was convicted of concealing some of his income so that he could get additional food stamps for his family. Essentially, he simply made a false statement on a form, and because of that false statement, he was charged and convicted of a Class 1 misdemeanor in the state of Pennsylvania. And that Class 1 misdemeanor and some of the charges in Pennsylvania made it a felony equivalent. Mr. Range had no prior serious criminal issues, and nothing has developed before or after that. Simply, he lied on a form to obtain food stamps, and he just lied about some of his income. However, because of that one ancient misdemeanor conviction, the government bans Mr. Range forever from possessing firearms. Mr. Range is barred from possessing firearms per 18 U.S.C. section 922G1 on account of that misdemeanor offense, which is claimed to be a felony equivalent. Mr. Range brought this lawsuit originally before a district court in Pennsylvania, and it was brought against the Attorney General and the ATF, and he was seeking declaratory and injunctive relief. He sought for the federal government to no longer be able to bar him from possessing or acquiring firearms only because of that one misdemeanor. However, the district court ruled in favor of the government on a motion for summary judgment. In doing so, the court used a two-step approach. They used a two-step approach. However, after the decision in the Supreme Court case, New York State Rifle and Pistol Association versus Bruen, essentially the use of the two-step approach has been barred and should no longer apply to 2A cases. After losing at the district court level, Mr. Range appealed up to the Third Circuit, and on review, a 3-judge panel in the Third Circuit issued an opinion upholding the lower court's decision, and there they also cited to Bruen. The 3-judge panel cited history and tradition, essentially in finding that individuals constitutionally entitled to bear arms are only law-abiding, responsible citizens, is what they said. So the Third Circuit panel found that his misdemeanor, although nonviolent, qualified under 922G1 and therefore excluded him from the class of the people afforded the right to keep and bear arms. Well, Mr. Range did not quit there, and he sought en banc panel review of that decision. And on review, the en banc panel in the Third Circuit found that the section 922G1 as applied to Mr. Range is in fact unconstitutional. Again, they applied Bruen against 922G1. In that decision, the majority discussed how their precedent had prior incorrectly used the two-step approach, which was expressly rejected by the Supreme Court in Bruen. They also went on to say that Range's appeal instead requires us to examine who is among the people protected by the Second Amendment. Range claims he is one of the people entitled to keep and bear arms, and that our nation has no historical tradition of disarming people like him. The government responded that Mr. Range has not been one of the people since 1995, when he pled guilty to the Pennsylvania State Court essentially for making that false statement on the food stamp application. So there, the Third Circuit nicely clarified what the whole issue is in this Range case. The government claims that Mr. Range is not part of the people mentioned in the text of the Second Amendment. On review, the court found that Mr. Range is part of the people protected by the Second Amendment, and his desire to possess firearms for self-defense is conduct that is protected by the Second Amendment. The court stated in their opinion that in sum, we reject the government's contention that only law-abiding responsible citizens are counted among the people protected by the Second Amendment. Heller and its progeny lead us to conclude that Brian Range remains among the people despite his 1995 false statement conviction. The Third Circuit then moved on to determine if the government showed that there is any historical evidence to support stripping Mr. Range of his right to keep and bear arms forever. And on that issue, the court stated that we hold that the government has not carried its burden. And based on that, the Third Circuit reversed the lower court's decision, and they reversed that order, and they issued a declaratory judgment in favor of Mr. Range. That judgment essentially prevents the government from enforcing Section 922G1 against him. Now, in response to that decision, the government then was put in a hard position. The only option really was to seek Supreme Court review, but the Supreme Court recently granted review to the Rahimi case, which dealt with a similar issue coming out of the Fifth Circuit, dealing with domestic violence restraining orders and who are the people afforded protection of the Second Amendment and the application of Bruen to that type of analysis. So there was a lot of risk for the federal government to seek Supreme Court review, but ultimately they did decide to file a writ of cert to the Supreme Court seeking review of this case. Now, back in November, the Supreme Court sent this Range case to conference, but then we received no orders of denial, no granting of the writ of cert, no relisting or a new conference date. And essentially what that means, and a lot of people are asking, what happened with the Range case? What this means is that the Supreme Court essentially has put this case on hold. So the Range case has been put on hold. This is no doubt because of the recent granting of review of the Rahimi case and the recent oral arguments that happened in the Rahimi case. The two cases, Rahimi and Range, deal with very similar issues, and the outcome of the Rahimi case will no doubt impact what happens going forward with the Range case, and also other 2A cases that are going to need to see how Bruen is applied to these areas of federal law and how the Supreme Court is going to handle this issue. Really, depending on the language in the Rahimi case, there may be a lot of 2A cases impacted both for good and also for bad. So it's going to be important to watch what happens in Rahimi. Keep in mind that the Rahimi case, there are a lot of bad facts in that case coming out of the Fifth Circuit for that specific individual, the whole domestic violence restraining order issue, and just generally he had a lot of bad, criminal history. It deals with a similar section of 922, but not specifically this one, 922G1. It deals with 922 and the domestic violence restraining orders, but again, similar issues about who are the people protected by the Second Amendment. I will note that after listening to the Rahimi arguments, there were multiple times that the Range case was expressly brought up by various justices, and that, signals that they are very familiar with the Range case. They were familiar with it when they heard the Rahimi case. They're going to be very aware of it when it comes into deciding the Rahimi case and trying to determine what the impact of Rahimi is going to be, not just for the 2A at general, but also for the Range case that's currently on hold. So this is one of those things that is developing, and we're going to hear very soon what is going to happen in these cases. Like I mentioned, the Supreme Court's term ends late June, early July, and that's when we, at the latest, will get decisions in the Rahimi case, and then we'll probably see the fallout here with the Range case about what's going to happen, what the Supreme Court's going to do, if they're going to grant, vacate, and remand. And oftentimes that's what happens. Keeps in mind, what we saw happen when they issued their Bruen decision. There were a bunch of cases that were put on hold, like the Duncan California magazine ban case, the Bianchi Maryland rifle ban case. A lot of those cases were on hold, and then after they issued their decision in Bruen, they issued grants, vacates, and remands in all those other cases that were on hold. So that is likely what's going to happen in the Range case as well, if the Supreme Court does not decide to take that up on their own and maybe expand on what they say in Rahimi. So definitely an interesting situation. I wanted to put these cases back on your guys' radar, especially since we are approaching very soon decisions in these cases. And very soon, we're going to hear a bunch of decisions coming out of the Supreme Court by the end of their term, not just in two-way cases, but a lot of other cases like Chevron deference, the ATF's bump stock cases, and a lot of these other cases are going to be decided very soon. So if we get any more information, if anything else develops, I will let you guys know. Also, if you guys like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of two-way news. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.